Good morning. Today, let us discuss the most common topic in bails, that is anticipatory bail. Of course, everybody knows about section 438 of the crpc. So during 1973 it came into existence, and it is otherwise called as pre-arrest bail, anticipatory bail, even though the word does not directly reflect as anticipatory bail in section 438 crpc. This anticipatory bail word was used by the law commission in its 41st report, anticipatory bail. So whenever any person is anticipating arrest in a criminal case, then he can tap the doors of the court with a request to release him on bail in case of arrest by the concerned police. That's why it is pre-arrest bail. Anticipating. Of course, friends, remember, there need not be any case to be registered. So even without registration of FIR also, you can approach the court for anticipatory bail. But normally, they don't give. Unless there is FIR, unless there is material. You have to prove that there is some material for granting bail for your anticipation. Normally, you cannot do guesswork. Some police may come and arrest me. It cannot be done. There should be some rock solid proof that police may arrest you. Then only they will grant the anticipatory bail. Right? So please remember section 438 crpc. It says any person, when he has got reason to believe that he may be arrested on accusation of having committed a non-bailable offence. Of course, please remember, for bailable offences, you have to surrender or you have to get bail, that's all. This applies only for the non-bailable offences. Then, in such a case, he can apply to the High Court or Supreme Court for a direction. Of course, High Court or Sessions Court for a direction that in the event of arrest, he shall be released on bail. Briefly, this is the brief facts of section 438 crpc. Right? So this facility is called the anticipatory bail, and actually this expression was used by that law commission in its 41st report. Right? First of all, let us know what is bail. Bail is release from custody. Bail is nothing but, so when a person is arrested, then only the term bail comes. Of course, since this is a pre-arrest, this is a novel item. So to grant bail is to set a person arrested at liberty. Of course, on surety being taken that he will be present he will appear before the court as and when required or for the trial. So basically, bail is release from restraint, release from custody of the police. So normally the act of arrest, first of all, takes place, and of course the act of arrest normally it curtails the freedom of movement and personal liberty of a person, and then only the bail order will be given. Of course, the bail order means it gives back the freedom to him once again. Of course, there will be some condition. The condition is that he has to appear before the court as and when required. Right? So please remember, an order of bail gives an assurance against police custody upon arrest. Is it not? When once you get an anticipatory bail, the police they have to release you on bail. Right? So please remember, normally if the arrest is made, what happens? Lot of harassment, lot of inconvenience, lot of humiliation. You may be knowing. For that purpose only, the so-called people, they apply for the anticipatory bail. Now, there is a very famous case law decided first by the Punjab and Haryana High Court. This is Gurubaksh Sidhia versus State of Punjab. Gurubaksh Singh Sibia, Sibia. Gurubaksh Singh Sibia versus State of Punjab, 1980. Right? So, let us go into the details of the case. This great man, Gurubaksh Singh Sidhia, he was a minister of irrigation. Yes, irrigation power in Punjab. At the time, Congress government was in power. Right? So normally, grave and serious allegations of corruption were leveled against him, including others like his officers and all these things. Right? Therefore, they filed anticipatory bail petitions. Number of anticipatory bail petitions were filed before the High Court. So, requesting the Honorable High Court to release them on bail in case of arrest by the police. Right? Then, the single judge could not absolve the issue. It was referred to the full bench of the Punjab and Haryana Court. Even the Punjab full bench of the Punjab and Haryana High Court, they dismissed the anticipatory bail petition, stating that no FIR was registered, no solid proof is there that he is likely to be arrested. In such cases, we are not going to grant you bail. But in that connection, the Punjab and High Court, Haryana High Court, they have framed a 8-point formula. Let us quickly, yes, they have discussed at length. Number 1, the power under 438 is extraordinary character and must be exercised in case of exceptional circumstance only. So normally you can't give bail under 438. Second, the section does not authorize grant of blanket anticipatory bail for offence not yet committed or accusation not yet leveled. If there is no accusation, if there is no offence committed, then they will not give. Just now I told you that you can file in cases where the FIR is not registered, but where the allegation is there, definitely you can file. Here, unnecessary, if the accusation is not there, if no accusation is leveled, what is the purpose of granting anticipatory bail? Then, so this power has got our limitations just like 437. Regular bail, all the conditions like all they will apply, like not going away, surrendering the passport, then supporting with the investigation, then not threatening witnesses. All these conditions will be there, right? And normally the petitioner must make out a special case for grant of anticipatory bail. Ordinary cases, definitely they can get bail, even though they are non-bailable in nature. But since he has to establish the special nature, right, then normally if the police, they have to arrest the accused, they have to send him for remand, there is a necessity, or if they have to go for recovery under section 27, in such cases it should not be granted, right? So normally the cases involving a death sentence and life imprisonment, no bail should be given. And in serious economic offences also, that is where the larger interest of public is there, section 438 should not be exercised. And lastly, 8th point, the court must be satisfied that allegations of malpractice must be substantial. వీడి మీద కావాలని కేసు పెట్టారంటేనే జనరల్గా బెయిల్ ఇవ్వడానికి ఛాన్స్ ఉంటుంది, రైట్? So now this matter has travelled to Supreme Court since the Punjab and High Court did not agree, and now Supreme Court has formed the guidelines. Of course, it did not totally agree with the conditions, 8-point formula of the Punjab High Court. The Supreme Court, after analyzing the history and intention of the legislature for providing such provision, they have found they formed the 5 points, right? Then, number 1, the anticipatory bail should be at the discretion of the judge, right? The ends of justice will be made by only the discretion, but you cannot fix him. Don't give bail in some cases like that. The discretion, judicial discretion, can be used by the judges, and because they have to trust the courts. Absolutely, the other principles which are given, of course, for murder, no giving like that. Only that, to be precise, to say they have given permission to the courts. Yes, to use their discretion in granting bail. May it be a murder case, may it be a case with a life imprisonment like that. So whether the allegation is made, whether the allegation modified or not, everything, it is totally, Supreme Court gave the discretion to the lower courts. The ends of justice will be better sounded, better secured by trusting the courts to act objectively and in consonance with the principles governing bail. Yes, they know all the principles. Therefore, they are the bail provisions which are recognized, and of course, by diversity. Okay, this much is sufficient. That means the Supreme Court has given full freedom to the judges to use their discretion. So that's all. Anyway, this case is that CBA. Corporation CBA is a landmark case in anticipatory bail. Please read it and encourage your legal knowledge. Thank you very much.